Friends, my name is Nizamuddin Ahmed Siddiqui and I am Assistant Professor of Law at West Bengal National University of Juridical Sciences, Kolkata. The present module entitled Sensitization of International Bodies, Interpretation of Judicial Decisions has been written by Professor Rohini Sen, Assistant Professor, Jindal Global Law School, OP Jindal Global University. The learning objectives of the present module include: number 1, to give students an overview of the relation between international court and international humanitarian law, to have an understanding of international human rights law as per judicial decisions. Friends, let us begin with history first. In 1990s, the citizens of various countries in the Middle East and the North Africa started to protest against their dictatorial regimes. In response to the protesters, many regimes resorted to violent or fatal measures. There was gross violation of human rights committed by these regimes. Some of these unpopular leaders were removed and subsequently were prosecuted in the national courts. However, it may be challenged for the national courts to prosecute its former leader because of biasness. It may undermine the effectiveness and ability of transitioning government to prosecute its former officials and heads. Peacekeeping after a conflict has become an internationally accepted norm. Thus, the national prosecution has an alternative of international courts, including international criminal tribunals, for instance, the International Criminal Court in The Hague, Netherlands. The link to armed conflict for prosecuting crimes against humanity was crystallized by the International Criminal Court as no, by being the first international tribunal to formally remove armed conflict as a de jure or de facto requirement for crimes against humanity. ICC can adjudicate over national judiciaries only when national courts are unwilling or unable. Moreover, the presence of an ICC prosecution of crimes against humanity outside armed conflict can galvanize civil society groups and other national actors like embassy officials, lawyers and judges to place stronger pressure on their governments in light of the prosecutions. For instance, the UN Security Council issued warrants for arrest with reference to ICC against Muammar al-Gaddafi and his associated for violently killing hundreds of protesters under his regime in 2011. Friends, let us now discuss the role of courts in identifying and interpreting the rules of international humanitarian law. We need to remember that judicial decisions are recognized as subsidiary source of international law. Treaties and customs are the main sources of international law under Article 38(1) of the ICJ Statute. The authoritative statement of the sources of international law in the Statute of the International Court of Justice treats judicial decisions as a subsidiary means for determination of the rules of law. Article 59 excludes the doctrine of stare decisis, the binding force of a judicial decision as a law creating precedent. Even though a judicial decision on a law is not binding, it however does carry legal weight. A judgment can be persuasive depending upon its quality. Though in practice courts consider the decisions of other tribunals, but the statute of the tribunals, it does not attach any value to the decision nor to the precedents. For instance, the Rome Statute speaks about precedent within the International Criminal Court itself, when it states in very general terms that the court may apply principles and rules of law as interpreted in its previous decisions. The constant reference to the case laws of other tribunals, as argued by some scholars, increases the danger of the field becoming overly self-referential. On the other hand, the decisions for courts like Nuremberg and Tokyo reflects agreement among the states that created them, and their constituent instruments set down provisions that were either declaratory of existing law or which had been gradually transformed into customary international law. Now, our inquiry must extend to discuss the elements of an armed conflict. The classification of conflicts has legal impact. The international law has traditionally been unable to prosecute perpetrators who have caused widespread domestic deaths because it was not an armed conflict. The existence of armed conflict triggers rights and obligations under the laws of war, called humanitarian law. The jurisdiction of international criminal courts only exists when there is an element of armed conflict. The International Criminal Tribunal for the former Yugoslavia, also known as ICTY, incorporated the armed conflict nexus requirement in the statute that created it. The ICTY, established by the UN Security Council in 1993 to deal with crimes of genocide, crimes against humanity and war crimes committed since 1991, is currently undertaking proceedings against about 90 people, most of whom were in leadership positions or were responsible for large-scale crimes in former Yugoslavia. However, in the prosecutor versus Tadic case, the court held that the substantive elements required from crimes against humanity were eliminated, though they still have loose effect for establishing jurisdiction. There has to be some essence of armed conflict in the crime, but not necessarily required to be the act to be the part of hostilities. Thus, every case before the ICTY occurring under the umbrella of the Yugoslav wars could have satisfied this element because every case could be connected to that armed conflict. International Criminal Tribunal for Rwanda, also known as ICTR, incorporated no requirement of substantial nexus, but mandated armed conflict as an indirect jurisdictional element. Even special courts of Sierra Leone had incorporated armed conflict directly to its statutes. The Special Court of Sierra Leone was established in January 2002 to bring justice to persons who bear the greatest responsibility for war crimes and crimes against humanity in Sierra Leone's long-standing internal conflict. Eventually, the Rome Statute defining the jurisdiction of International Criminal Court or ICC did away with requirement of nexus of the armed conflict. The international law lacks definite definition of a domestic uprising becoming an armed conflict. However, the most commonly applied definition requires protracted conflict between armed groups. The Geneva Conventions and their protocols do not clearly delineate the threshold for armed conflict. It has been argued to use factor-based approach by weighing the organization of parties, intensity of conflict, degree of violence and duration to determine the armed conflict. The International Criminal Court addressed the presence of armed conflict in situations of Democratic Republic of Congo, Uganda, the Central African Republic, the Republic of Sudan and Cote d'Ivoire. Democratic Republic of Congo already has a well-established armed conflict. The situation dealt with the deadliest armed conflict after the Second World War was the Second Congo War. In the situation of Uganda, the court established protracted armed conflict of 5 months. Sudan conflict, a decade long, included allegations of genocide. The case features the first ICC arrest warrant for a sitting head of state, President Omar Hassan Ahmad al-Bashir, and he is also the first defendant facing charges of genocide. Furthermore, the prosecutor alleged that there was a protracted armed conflict between the Sudanese armed forces, the Popular Defense Force, and the Janjaweed militia against the organized rebel groups. ICC also dealt with cases with allegation of crimes against humanity, but outside armed conflict, for instance in Kenya and Libya. Let us now discuss the nexus between domestic and international law. The parameter of international humanitarian law has broadened because of modern warfare. The nexus between the international and domestic laws helps in the evolution and implementation of the international humanitarian law by the courts. The advantage can be analyzed, for instance, through direct participation in hostilities. The fact that terrorist groups like Hamas, Hezbollah or Al-Qaeda have developed into significant political actors raises the question whether mere membership to these organizations is enough in order for an individual to be considered a legitimate target. There is no specific definition of direct participation in hostilities. Traditionally, international law required for civilians to be part of a direct participation, not engaged in military action and suspected of terrorism. This, on one hand, would be a blatant departure from the fundamental principles of international humanitarian law. On the other, requires broad definition to cover preparatory stage for an attack. It has been noted that direct attack should not include support or affiliation to the adversary. It is also argued that if liberally interpreted, the civilians would ultimately distance themselves from the conflict. The domestic Supreme Court of US has, for instance, held that Hamdan was a combatant even though he was just a driver of bin Laden. The preliminary stages before the actual use of force were included within the scope of direct hostilities by the Supreme Court of Israel. Striking a balance between the protection of human rights and accommodation of the shifting realities of the battlefields is very relevant. The jurisprudence nexus between international court and domestic court helps in the development of international humanitarian law and thus ensuring the balance. For instance, the Court of Appeal of England and Wales was guided to rule on what constitutes as terrorism by the dicta of an international tribunal. Special Chamber of the Special Court for Lebanon also did the same things. Let us now move to the role of International Criminal Court. Judicial decisions as subsidiary sources of law may help in the development of international law. They can bridge existing gaps, accommodate old laws in changing circumstances, and push the boundaries for effective development of the laws. But first, we need to address the gap filling and law creation role of the decisions. The International Court of Justice endeavors to perform the following three functions. Number one, the function in considering and elucidating the existing law and in defining and confirming it. 2. The function of modifying in conformity with the existing conditions of international relations, provisions which, though in force, have become out of date. And number 3, the function of creating and formulating new precepts both for old problems where no rules exist and also for new problems. The issue of gap in international law has been referred as the situation of non-lique, which proposes restriction in the evolution of international law. Non-lique is where the court comes to the conclusion that the situation in a particular case has no answer from the governing system of law. Judicial decisions is an apt tool to enforce Article 38(1)(c) of the ICJ statute, which talks about general principles of law, thereby removing the last vestige of the possibility of gaps conceived as a deadlock in the way of the settlement of a dispute. However, the decision has to be well within the limits of existing international laws. The application of general principles of humanitarian law through judicial function will elaborate the meaning and their application to specific situations. The judges, as per the opinions of few scholars, should articulate the preferable law that should be applied to the circumstances to resolve conflict and avoid the situation of non-lique. This function does not amount to judicial lawmaking. On the other hand, it is argued that the principle on which the court acts, be it one of prohibition or one of authorization, leaves no room unoccupied by law and consequently no space available to be filled by the non-lique doctrine or by arguments traceable to it. It is, for instance, argued by the nuclear states that the law permits use of nuclear weapons under certain circumstances and has thus not expressly prohibited its use and does not involve the matter of gap in law. This approach may grant a degree of legality to everything that is not expressly prohibited, even though the law may be deliberately silent or neutral on the matter. While the nuclear weapons advisory opinion has been criticized as an abdication of the judicial function for permitting a non-lique, it does highlight the differing interpretations of the non-lique doctrine and the role of international judge in addressing the apparent gaps. To fill the gaps, the court may create law when interpreting the existing law. Its decisions may not be categorized as mere determination or elucidation of the law. Judicial development may amount to lawmaking. The traditional function of the judiciary is limited to find and apply the codified law, which is losing its ground domestically. There is blurred boundary which separates articulation of codified laws and its judicial legislation. Using creative approach like purposive interpretation, the court can expand its role and actually carry out the functions of legislation. This could eventually threaten the state's sovereignty, however, and therefore, if exercised within reasonable limits, it may also create a destructive trap. Let us now discuss the role of court in international humanitarian law. Contemporary humanitarian law is the outcome of a long normative process, whose more immediate origins date back to the late 19th century with the movement towards codification of the laws and customs of war. The Hague Law, the Geneva Law are two prominent sets of rules. The International Court of Justice, in its advisory opinion on legality of the threat or use of nuclear weapons case, stated that international humanitarian law contains rules regarding the conduct of hostilities and as well as those protecting persons in the power of the adverse party. The court establishes that the fundamental ethical values of international humanitarian law are similar to that of human rights law. They both are concerned with human dignity. The court recognizes the importance of applying human rights treaties even in the time of armed conflict. It also confirms that the provisions of Geneva and Hague Conventions are declaratory of customary law. The rules of international law, which are so fundamental to to ensure international public order that the states cannot derogate from them form the notion of jus cogens. International Court of Justice has addressed the issue of jus cogens or related concepts such as obligation erga omne in various contexts closely linked to humanitarian law. For instance, the idea of fundamental human rights, the prohibition of threat or use of force, and the people's right to self-determination. The idea about obligation erga omne was first referred by the court in its advisory opinion on reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, 1951. It held that outlying genocide fell within the obligation erga omne, which is an obligation towards the entire community of states. The court, through a series of case laws, has established various fundamental principles of international humanitarian law. For instance, the advisory opinion on the legality of the threat or use of nuclear weapons, as we have already discussed. Let us now move on to the principles. Fundamental principles relating to the conduct of hostilities. The principle of distinction between combatants and not combatants. According to the court, this principle is aimed at the protection of the civilian population and civilian objects and establishes the distinction between combatants and non-combatants. The states must never make civilians the object of attack and must consequently never use weapons that are incapable of distinguishing between civilian and military targets. The distinction between non-combatant and combatant forms the cornerstone of international humanitarian law. This basic principle derives from the axiom that is the very foundation of humanitarian law, namely that only the weakening of the military potential of the enemy is acceptable in time of armed conflict. Judiciary acknowledges the principle of distinction, the prohibition of indiscriminate weapons and the prohibition of attacks against civilians. It confirms that the prohibition of the use of indiscriminate weapons is an integral part of customary principle of distinction under humanitarian law. The prohibition of the use of weapons that cause superfluous injury or unnecessary suffering is again an interesting area. According to the court, this is the second cardinal principle on constituting the fabric of humanitarian law, which governs the conduct of hostilities. According to this principle, it is prohibited to cause unnecessary suffering to combatants. It is accordingly prohibited to use weapons causing them such harm or uselessly aggravating their suffering. In application of that second principle, states do not have unlimited freedom of choice of means in the weapons they use. The court defined the unnecessary suffering caused to combatants as harm greater than the unavoidable to achieve legitimate military objectives. The assessment of the legality of a weapon or its use depends therefore on the balance between the degree of injury or suffering inflicted and the degree of military necessity in the light of particular circumstances of each case. The greater the military advantage, the greater will be the willingness to tolerate higher levels of suffering. Let us now move to discuss the martens clause. The court observed that the martens clause was first included in the Hague Convention II with respect to the laws and customs of war on land of 1899 and which was proved to be an effective means of addressing the rapid evolution of military technology. A modern version of that clause is to be found in Article 1, Paragraph 2 of Additional Protocol 1 of 1977, which reads as follows: In cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principles of international law derived from established custom, from the principles of humanity and from the dictates of public conscience. The court affirmed that the martens clause is a customary rule. Thus, it is of normative status which regulates the state conduct. Friends, let us now move to discuss the treatment of persons in the power of the adverse party. In military and paramilitary activities in and against Nicaragua 1986, the court laid down minimum standard of humanity. The general principle of humanitarian law expressed in Common Article 3 goes beyond the conventional restraints of the Geneva Conventions and is applicable to every type of armed conflict, whether internal or international. Let us now discuss the implementation of international humanitarian law. The case laws coming from International Court of Justice enable three basic rules governing respect for international humanitarian law to be drawn. Number 1, the obligation to respect and to ensure respect for humanitarian law. Number 2, humanitarian assistance. And number 3, the prohibition of genocide. With this, friends, we come to an end of this module. I thank you all for your patient hearing.